That's so awesome.
And Your Honor, before the jury comes back,
Yes.
I would like to briefly confer with Mr. Garahan about a proposed stipulation
Okay.
as it relates to what we talked about. I haven't seen it myself.
I had Lexi is printing out one line.
Oh, what?
One line. If you want it, that's why you can talk.
Mhm.
And he would take it from Jersey to Tarrant County on a certain day. Certain days he was transferred.
Okay.
Sure tell that he would-
Yeah.
That's all. I said. I'll show you.
That's your point.
Okay.
I can make sure.
Yeah, show it to me.
Either way, just don't go beyond.
About that, he was transferred to Tarrant County
And
and then brought to Bear County.
Yeah.
Okay.
I mean, that's essentially what it said.
Yeah, I mean, so y'all want me to approach my witness and ask him, that's what I'm gonna ask him, that's his response, because that's truth.
Absolutely.
Yeah, would you like me
Yeah.
to, can I do that? Would you like me to do it that way?
Yeah, either way.
Okay.
If you want to. Judge, I think we've agreed on what it's gonna say. They're printing it out, but I think able counsel over the state
All right,
can
let's go.
instruct the witness and that
Let's-
way we'll get it.
All right, let's go on the record. We're back on the record in 2019 CR 12495 State versus Tamar McIntyre. We're gonna have parties announced for the record, state.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre,
Just one
who's
moment.
present.
All right, and then it's my understanding that with regards to evidence related to Tarrant County, you all have reached a stipulation?
Yes, Your Honor.
But I believe they're printing it up, but I think to say, so we don't delay it anymore, I trust Mr. Garahan, he's gonna talk to the witness for just a brief second, and then we can move on.
Yes, Your Honor. I talked to defense counsel, and I don't believe there's any objection I was gonna ask. It is a truthful statement if I ask, Sergeant Juarez, was Tamar McIntyre transferred from New Jersey to Tarrant County and from Tarrant County to Bear County? And that was gonna be the question, and I believe that would be in there. Yes, that is correct, and if that's sufficient for the defense.
That satisfies the stipulation.
All right, and then with regards to those questions, I'm assuming no one would have any objections to the state leading because it's your stipulation?
No objections. to
No
that.
objection.
All right, are you all ready to
It'll be
proceed?
the only time we
One
have
more to the
it.
picture.
Yes.
Like, I'm gonna say, well, the same one, not gonna, what did this happen in New Jersey?
Gentlemen, I'm just run for.
I ran in New Jersey, but then transferred to Tarrant, and then transferred to Bear County.
Yes.
That's a yes.
Yes, yes.
So defense, are you ready?
Yes, Your Honor.
Okay, all right, you can bring the jurors in. Thank you. Oh, everyone, please be seated. All right, you're still under oath. If you'll just restate your name for the record, please.
Juarez.
All right, state, you may continue.
Yes, Your Honor, thank you. Sergeant Juarez, I believe you were speaking about, Tamar McIntyre being apprehended in New Jersey. And after he was apprehended in New Jersey, was he then transferred to Tarrant County?
Yes,
And then was he transferred here to Bear County?
yes.
Thank you. Now. That was on, just after the lunch hour, that was on June 30th, that, again, that Tamar was apprehended in New Jersey, is that correct?
Yes, sir.
Then let's fast forward to August 22nd, 2017. What is significant about that date?
Joanna Reyes was arrested.
And was she, where, you recall where she was arrested at?
Hector County, Texas.
And then was she subsequently transferred back to Bear County?
Yes, sir.
And when she was transferred back here, did you, or were you ever contacted to, that she wanted to speak to you?
Yes, sir.
And did you set up a interview with Joanna Reyes at that point?
Yes, sir.
And did you go to the actual jail or facility to interview her?
Yes, sir.
And were you given that opportunity to interview her at that time?
Yes, sir.
And did you speak to her about the case that we are here in court today for?
Yes, sir.
And did you show her any photographs?
Yes, sir.
One 128, since it's in 128, 130, or 131. If you can flip through those.
Yes, sir.
Now, these photos have already been entered into evidence. Are these the photos that you showed Joanna Reyes?
Yes, sir.
And did she identify each individual in these photos?
Yes, sir.
And did she identify each of these individuals that are in these photos that were in the car with her that day on April 23rd, 2017?
Yes, sir.
And can you tell the jury who is named in these photos?
Tamar Mcintyre was a front seat passenger. Jalen Bell and Jeremiah Rodriguez were in the back seat.
After discussing this case with Ms. Reyes on that day, at the conclusion of that interview, did you determine whether Joanna Reyes was a participant in this case?
I told Joanna that I believe she was a participant in the case and that she was going to be charged with capital murder.
Now, this is exactly, you had told in previous testimony today, before lunch, that you had spoken to her parents and told them that she was a suspect in this case.
Yes, sir.
And after the conclusion of that interview, did you reach out to a Jeremiah Rodriguez and Rebecca Rodriguez to obtain another interview?
Yes, sir. The next day.
And so on September 6th, 2017, were you able to have that interview with Jeremiah Rodriguez and Rebecca Rodriguez?
Yes, sir.
And after that interview with those individuals, was that useful for this case in your investigation?
Yes, sir.
And at the end of that interview, no, let me retract that statement, that question. Let me ask you again, on September 6th, again, did you contact the Dallas Police Department?
Yes, sir.
And what did you contact them for?
They had a backlog, still trying to get that stolen gun over here to Bear County.
And that's the gun that Jalen Bell was picked up with in Dallas, Dallas, Texas.
Yes, sir.
And do you know at that point, was the gun transferred to Bear County on September 6th, 2017?
I don't think it was at that point, but I'm not positive when it got transferred.
And let's just talk about that firearm in particular. Are you aware of when it did make it to Bear County?
No, I don't. I'm not aware, sir.
And in fact, do you recall when you became aware it was in Bear County?
Last 2024. Last year.
2020, so last year.
Yes, sir.
And at that particular point was, what did you request about that firearm or what to do with it?
The firearm was sent to the Bear County Crime Lab. along with the shell casing that was recovered at the crime scene at the Chick-fil-A for comparison.
And you requested it be sent to be compared, and you got the results from that, is that correct?
Yes, it didn't match.
Now, you interviewed all these individuals. Wait, did you ever have an opportunity to interview Tamar McIntyre?
No, sir.
Did you ever have the opportunity to interview Jalen Bell?
No.
Now, this blue cell phone that we discussed earlier, it's entered into evidence, and you had a search warrant made for that phone, is that correct?
Yes, sir.
And did you hand that over? I guess what department would you hand that over to get that processed?
So at that point, it was a crime scene unit, they had the capability to do cell site extractions for that period.
And so is that who you would have handed it over to?
Yes, sir.
Now, speaking of search warrants, you mentioned earlier testimony that you got a search warrant for Mark Salvador's phone number, and that you also got one from Joanne Reyes. Is that correct?
Yes, sir.
Can you recall this? Well, not the search warrant number, but the phone numbers that are affiliated with Mark Salvador, and then also the one that is affiliated with Joanne Reyes.
For Joanna Reyes, it's 210-331-8356.
Thank you.
For Mark,
Just to expedite it, and you can refer to your page 31 under the consent to search and search warrants.
thank you. For Mark Salvador, it was 210-382-3826.
Thank you. And I know that we haven't marked this, but the jury is seeing you flip through some pages up there. What are you looking at?
This is my prosecution guide, pretty much my report.
So that's your, in a sense, a police report of your investigation of this case.
Yes.
Okay, thank you. Now, did you ever investigate anything about Tamar McIntyre's Twitter account?
Yes.
And do you recall what, I guess, the handle or the name of that Twitter account was?
TK47 USA.
And how was that useful for your investigation?
And identifying and getting a date of birth for Mr. McIntyre.
And through this portion of information on Tamar McIntyre, was that the only information that you used to identify Tamar McIntyre?
Other than lineups? From-
No, I'm just saying that
Oh.
in the totality of your investigation.
Yeah, from the witness statements that were in the car. There was evidence found in the car, such as the cell phone, the letter in the trunk of the car. The other people in the car placing him in the vehicle, which was corroborated by the independent witnesses that did not know who was in the car, but were able to corroborate statements and the video of the shooting and at the Chick-fil-A and then at El Potosino.
Thank you. Now, do you recall that CSI in this case obtained what they call swabs?
Yes.
And those swabs, well, what are swabs? What do you define them as?
They're I mean, they look like, they're just Q-tips. They're like wooden sticks with a Q-tip on top.
And from your knowledge and training experience, is that used to collect possible DNA or biological evidence?
Yeah, they swab items to see if there's any DNA left on there, which is different. Because sometimes they do it if like there's blood or saliva or something visible. This is more where it's the surface of things, vehicles or doors, things of that nature.
I mean, are you very aware, or if you are, of like touch DNA or anything like that?
Yes,
And is that also a possible reason why they would do swabs?
yes,
Okay. Now, in this case, there have been many swabs that were testified to that were done. Were those ever tested in the lab?
no, sir.
And is there a particular reason why these weren't tested?
So, I made the decision not to submit them. I felt that with the evidence that I had with Mr. Mcintyre being placed in the front seat of the car and other evidence, it would have helped, but I don't think it would have hurt the case because they don't. So it's such DNA, so it doesn't necessarily mean it's going to come back to anybody at all. And I felt with the other evidence I had, it wouldn't change anything.
So are you saying that, let's just say hypothetically, one of these swabs would have came back to a different individual, that if it was swabbed inside the car in the front passenger seat, if it would have came back to a different individual, not Tamar McIntyre, would that have changed your conclusions on this case?
No,
Would it still be that your conclusions are that Tamar McIntyre shot and killed Mark Salvador with a deadly weapon on
Yes, there was
April 23rd, 2017?
yes, there was more evidence to support that conclusion.
Now, Ms. Snell had been in here earlier to testify about latent prints, and she identified Jalen Bell's fingerprints or latent prints on the cell phone of Mark Salvador, which I believe you testified to earlier, and also that Jeremiah Rodriguez latent prints were found on the exterior of the vehicle. And she also testified that she tested them against Mark Salvador, Joanna Reyes, and Tamar McIntyre. You know, in this situation, I guess my question is that Joanna Reyes admitted to being in this vehicle, but yet none of her fingerprints were found. Is that common in cases through your experiences?
Yes, sir. Yeah. So the phone is another good example. It was the victim's phone. He used it. It's his phone, and even his fingerprints weren't found on there, which is kind of like the swabs and like my decision not to submit it because it's not always a guarantee that anything's going to come back to it. But the fingerprints did come back to Mr. Bell.
Thank you. And again, you know, Mark Salvador, like you said, it was his phone, but from all intents and purposes, from your investigation, Mark Salvador was on that hood of that vehicle, and many people testified that he was grabbing onto that vehicle, but yet none of his fingerprints were found.
Correct.
And also, there's testimony that Tamar McIntyre was in that vehicle. However, his fingerprints were not found anywhere in that vehicle also. Is that correct?
That's correct.
And through your investigation, you determined that the death of Mark Anthony Salvador was caused by Tamor McIntyre while he was trying to commit robbery of Mark Salvador?
Objection leading, calls for the
Sustained.
ultimate issue. Move this,
What-
instruct the jury to disregard the question.
Ladies and gentlemen, you to disregard the last question.
Motion for mistrial.
Denied.
What are your conclusions after the totality of your investigation on your belief of Tamor McIntyre's actions that day?
Objection calls for opinion on the ultimate question.
Sustained.
No, you can't.
Objection.
You
You're
can't
not
answer.
allowed to answer.
Were there also clothing items contained within that car that were related to Tamor McIntyre?
Yes, sir.
And so, including evidence of the letter and the phone obtained from that vehicle, is that correct?
Yes, sir.
Thank you, Your Honor. We'll pass the witness.
May I proceed,
Defense.
Your Honor? Good afternoon, Detective. How are you?
Very good.
I'm sorry, it's Sergeant now, right?
It's okay, sir.
So fair to say, there are a lot of moving parts in an investigation like this, right?
Yes, sir.
And you rely on a lot of other people to do some of this granular, fine detail work, like fingerprint examination, extraction of cell phone data, collecting evidence at the crime scene, interviewing witnesses, et cetera, right?
Yes, sir.
You could not possibly do all of that as one person.
No, sir.
But of course, when you're delegating that many responsibilities, you're dependent on those people doing their jobs correctly, right?
Yes, sir.
And you have to trust that when they report back to you something, that their conclusions and that their opinions are something you can rely upon, right?
Correct.
There's always human error, though, in every case, right?
Yes, sir.
Okay. So I want to talk about, in terms of how this investigation developed, would it be fair to say that there's the physical evidence and then there's what people told you, right?
Yes, sir.
Okay, so let's talk about the physical evidence for a second. You know from physical evidence that Mark Saldivar is dead, right?
Correct.
And that he died from a gunshot wound.
Correct.
You know that there was a 9mm shell casing found next to his body.
Yes, sir.
You also know that there are shell casings all over the streets of San Antonio for all sorts of different reasons, right?
Yes, but there was a body next to this one.
Understood. But what I'm asking is, the examination that was done in this case never told you that that shell casing is definitively the shell casing that produced the bullet that killed Mr. Saldivar, right?
So I have video evidence and witness evidence that a shot.
And we're going to get to that in a moment.
Yes, sir.
I don't want to jump ahead. I'm just
Okay.
saying, as far as that 9mm shell casing is concerned, obviously, it's a shell casing next to the deceased person. You're investigating that man's death. I understand that. I'm just saying there's nothing that conclusively says that 9mm shell casing produced the bullet that killed him. It just is strongly coincidental, right?
That's a little more than a coincidence, sir. Yeah.
Okay, but you know definitively it may not be the shell casing.
It's more than likely to be the showcase.
Okay.
Yes, sir.
I'll more than likely. Understood. So you found a 9mm shell casing next to this man's body in the parking lot of the Chick-fil-A, correct?
Yes, sir.
You acquired surveillance footage of this incident, right?
Yes, sir.
And that surveillance footage showed a car pulling into the Chick-fil-A, a man standing on top of the vehicle, and then someone shooting him, right?
Yes, sir.
And you knew from that generally that you're looking for a small, dark-colored four-door sedan, right?
Yes, sir.
And you put a be on the lookout for that vehicle.
Correct.
And you knew that there would be extensive damage to the front windshield of that car, right?
Yes, sir.
And you then a few days later acquire more physical evidence in the case at the parking lot of this Mexican food restaurant, right?
Yes, sir.
And so you know that you have a damaged SD card found in the parking lot, right?
Yes, sir.
And you found that subject vehicle. You found a black four-door Kia with a lot of damage to the front windshield.
Yes, sir.
And you found various items, some of which may have belonged to people in the car, some of which may not have belonged to people in the car, scattered around that parking lot, right?
Yes, sir.
Okay. You did not find a digital camera, correct?
Correct.
You didn't find any, well, you didn't find a digital camera, correct?
Correct.
You acquired surveillance footage from that Mexican food restaurant, right?
Yes, sir.
And so you see individuals getting out of that black four-door Kia on the date in question.
Yes, sir.
And so as far as your physical evidence is concerned, right, that's sort of the universe of physical evidence that you have at your disposal, correct?
Yes, sir.
I mean, you have gunshot residue on the deceased's hand, correct?
Yes, sir.
You later on acquire a 9mm pistol obtained from Jalen Bell in Dallas, right?
Yes, sir.
You do comparison to that, and your analyst tells you that that's not the gun, correct?
Yes, sir.
You don't have any other weapons recovered from the vehicle or any other crime scene.
No, sir.
You do have multiple magazines,
Yes,
right?
sir. 3 magazines.
Some are 380 auto and some are 9mm.
Correct.
You don't have any fingerprints on those magazines.
No, sir.
You have a fingerprint belonging to Jalen Bell on the cell phone that you found tossed out of the car in the Chick-fil-A, right?
Yes, sir.
You have, and you spoke to, well, before I get into what you spoke to, you did an extraction of a blue iPhone in the vehicle that you found in the vehicle, right?
Yes, sir.
You believe that that phone belongs to Tamar McIntyre, correct?
Based on the data on it, yes, sir.
And you found some belongings of Mr. McIntyre's in a gym bag, right?
Yes, sir.
You found a piece of mail addressed to Mr. McIntyre.
Yes, sir.
Okay. You know that that vehicle is registered to Joanna Reyes' father, I believe.
Yes, Juan Reyes.
You have fingerprints of both Mr. Bell and Mr. Jeremiah Rodriguez that were found in the car, correct?
Yes, sir.
Okay. In terms of physical evidence, are there significant things that I'm leaving out of that recitation?
No, sir.
Okay. So if we just look at the physical evidence of the case, you know that the case involves a four-door black Kia, right? The case involves a dead man, Mark Saldivar. The case involves, I'm sorry, you were going to say something.
No, yes, sir. I was in agree. So
Thank you very much. Appreciate that. You know that the case involves a 9mm shell casing, correct?
yes, sir.
I did forget one thing. When the car was searched, a live 380 auto round was found in the front passenger seat of the car, correct?
That's correct.
You found a condom in the car as well, correct?
Yes, sir. Under the front passenger seat.
So you know that someone was shot, and you know generally where they were shot, and you know that they were on top of the car when they were shot, right?
Yes, sir.
Okay. The physical evidence doesn't tell you who shot, correct?
No, sir.
The physical evidence doesn't tell you who was in the front seat and who was in the back seat, right? Let me back up because I think I know why you're thinking. You obviously do have the footage from El Potosino that shows people getting out of the car, right?
Correct.
Okay. But you can't look at those images on the footage and say, oh, that's Tamar McIntyre, that's Jalen Bell. Like you just without any other information you've learned in the case, right?
Well, yeah, without any information that I do have.
Without people telling you that's me, that's them, you wouldn't be able to say from looking at that footage who's who.
So yes, the footage isn't clear enough, but I do have that information.
And we'll get to that in a
Okay.
moment. I'm just trying to take
Yes,
stock
sir.
of what you've acquired physically.
Yes, sir.
Okay. And you don't know whether that black four-door Kia went directly to that Mexican food restaurant after it left the Chick-fil-A parking lot, right?
That's what I was told, that it went directly there. Sir. So that's what I,
Okay,
Yeah, go ahead.
I'm just asking, does the physical evidence tell you whether the Chick-fil-A parking lot, whether that car went from the Chick-fil-A parking lot directly to El Potosino Mexican restaurant? So the physical evidence could be consistent with that, and it could be consistent with them making a pit stop someplace or stopping some other location, right?
Yes, sir.
They could have had a Chinese fire drill and everybody changed their seats. The physical evidence wouldn't tell you one way or the other.
No, sir.
Okay. The physical evidence doesn't tell you which gun was used to shoot Mark Saldivar, right?
No, sir.
The physical evidence doesn't tell you what was stolen from Mr. Saldivar, correct?
So the physical evidence includes the video. A backpack was taken and Mr. Bell was seen stealing a backpack.
Okay. So you see Mr. Bell in the video putting on a backpack,
Yes,
right?
sir.
But let me ask you this. There's no footage of Mr. Saldivar getting in the car with the backpack,
That's
correct?
correct.
And so in terms of just what the physical evidence shows us, you see a man putting on a backpack.
Yes, sir.
That does not tell you that the backpack was stolen, right?
By itself, no, sir.
Okay. So suffice it to say, despite the fact that there's a lot of physical evidence collected in this case, there's still a lot of unanswered questions from just the physical evidence, right?
Yes, sir.
It was necessary for you to talk to people who might have firsthand knowledge of things in order to better develop your investigation, correct?
Yes, sir.
And some of those people that you spoke to were innocent bystanders around the Chick-fil-A on that day, right?
Correct.
And they gave you accounts that were consistent about some things, right?
Yes, sir.
Like, for example, they saw that there was something going on unusual in that car before it pulled into the Chick-fil-A parking lot, right?
Yes, sir.
Some people said that they were playing around. Some people said they were fighting. You know there are differing accounts about that.
Yes, sir.
Some people describe the people in the car as all Hispanic. Some people describe the people in the car as being African American, right?
Yes, sir.
Some people said the African American in the front seat had an afro with a blonde streak in it. Some people said he had short cropped hair.
Yes, sir.
So a lot of people got a general idea of what happened, but I mean, is in your training and experience, is that pretty par for the course for innocent bystanders watching something like this happen?
Yeah, people on a Sunday afternoon minding their own business and something like that happens, they have different perspectives of it.
So it gives you
and
like
impressions.
a rough sketch of what happened, but not like the kind of detail you need as a detective to really drill it home.
Yes, sir.
Okay. And then, so if we take the physical evidence plus the innocent bystanders, there's still a lot of things that you don't know
Yes,
from that information, correct?
Yes.
Like we still don't know why they were playing around or fighting in the car.
correct.
We still don't know who was in which relative seat in the car.
Yes, sir.
We still don't know who shot the gun.
Yes, sir.
We still don't know which gun it was.
Okay, by name, you're right. Yes, sir.
Okay. We still don't know which gun it was.
Yes, sir.
Accounts also differ about how the gun is used from those innocent bystanders. You'd agree, right?
How, sir?
Well, you recall some of the witnesses told investigators that the gun was pointing up,
Yes, sir.
and some investigators said the gun was pointed at
Yes,
the
sir.
deceased. And some people said that the gun was being used as a bludgeon instrument.
Yes, sir.
And some people said that the gun was in a different hand and that the blows were coming with just a closed fist.
Yes, sir.
So we still don't know exactly how the fight unfolded in the car, right?
No, sir. Just everybody's perspective of what they saw.
Right. And there's no real way for you to weigh one or the other, right?
No, I just put all of their input into the investigation.
Understood. The accounts differ as to how many shots were fired, right?
Yes, sir.
I think we have some people that say one, some people that say two, some people that say three.
Yes, sir.
Okay. So you've got a general idea of what's going on. And you have some physical evidence that does give you a sense of who was in the car. But you'd agree with me that without someone talking to you about what happened inside of that car, you wouldn't be able to file a capital murder charge on anybody, right?
Well, yeah, because I don't have names.
Well, sure. You don't have names for one,
Yeah.
right? Sometimes when people die, in a gunshot related incident, it's murder, right?
Yes, sir.
Sometimes when people die in a gunshot related incident, it's self-defense.
Yes,
Defense of property could be a reason someone takes another life with a gun, right? So those things are things. Defending a third person could be a reason to take another life with a gun, right?
yes, sir.
Those are all things without input from people who were there. You don't have enough information to rule those things out, right?
Correct.
Okay. So that leads us to Joanna Reyes and Jeremiah Rodriguez, right?
Yes, sir.
These are people that you were able to interview,
Yes.
correct? And from their interviews, you learned that, I mean, they're the ones that tell you that Mr. Mcintyre was the one who produced a pistol, right?
Yes, where he was seated and that he produced the pistol. Yes, sir.
Okay, so they give you the seating arrangement in the car. And they give you that he's the one who brandished a firearm, correct?
Correct.
They're the ones that tell you that he's the one who shot Mr. Saldivar, correct?
Correct.
They're the ones that tell you that he's the one who started the fight, correct?
Correct.
They're the ones who explain why Mark Saldivar was in the car, right?
Yes, sir.
They're the ones that explain, I mean, they just give you their opinion. It wasn't self-defense, right? They helped you rule that out.
I mean, I asked them the question and they answered that they didn't believe it was self-defense.
Okay, so when you go into an investigation, it's important not to have a preconceived idea about who's responsible and what happened, right?
Yes, sir.
That's the way we make mistakes, is by having the idea of what happened so buried in our head that we ignore other things that might tell us something else, correct?
Yes, sir.
Okay. So going into this, based upon the physical evidence, you understand that any one of those four people in the car could potentially have been the shooter.
It was the front seat passenger.
Okay, well, I mean, what I'm getting at is the physical evidence we just talked about doesn't tell you who was the front seat passenger, right? We agree on that much.
Yeah, yes, but I don't look at, you're breaking it down and I didn't look at it just broken down.
Okay, well, when you're not looking at it just broken down, the missing piece of your puzzle comes from Joanna Reyes and Jeremiah Rodriguez, right?
Yes, sir.
Their information is the only information that you get in this investigation that tells you about the goings on inside the car, correct?
That's not the way the investigation goes, because I combined all the elements that you explained to come to the conclusion that Mr. Mcintyre shot and killed Mr. Saldivar.
Okay, well, I mean, if I mix flour and water together, I'm never going to get a porterhouse steak, am I?
Your Honor, I'm gonna object to argumentative.
Sustained.
If the evidence by itself doesn't tell you a specific fact, then I guess what you're suggesting is that what they've told you is corroborative, and that's why you can add the physical evidence back into this and reach
So-
the conclusion?
So the physical evidence is still a part of it. It's still part of the case. I have the independent witnesses that, yes, they did have differing views and perspectives, but generally, gave a summary of the events that they saw. They don't know who's in the car. They don't know what's happening, but they also don't have any reason not to be truthful.
Okay, but we acknowledge that those individual people, while they give similar accounts, have big differences, right? The race of the people in the car is a significant difference.
Yes.
You agree?
Yeah, yes, they do.
The number of shots fired is a significant difference, right?
Yes, sir, but that's normal.
Well, and of course it's normal. I mean, I get that. What I'm asking is okay. Let's say that hypothetically, you're investigating someone who posts videos of them giving a talk on some subject matter in their living room, and you're investigating them for a crime. And someone comes forward and says, they committed a crime. And I know that because this man in his house has, you know, a marble mantelpiece and a cuckoo clock and green walls and everything else. And you look at that, and everything that that person told you is something they could have gotten from watching his videos online, right? Would that be corroborative of what they're accusing him of?
No. Are you saying like, would that suffice?
Right.
No.
Okay. Because what everything they're telling you is something that they could have known independently, right?
Yes.
Okay. So in this situation, Joanna Reyes and Jeremiah Rodriguez told you that the decision to rob was made by Tamar McIntyre in the moment, right?
Yes.
And they denied having anything to do with it, correct?
Yes, sir.
They were totally surprised that this had occurred.
Correct.
And then they talk about things that they saw and observed in the car, right?
Yes, sir.
But many of those things either are just things that are in the car, or they're things that you can't know one way or the other. You have to take their word for it. Is that a fair
Correct.
way to describe it?
No.
Okay. So as a homicide detective, fair to say almost none of the people that you ever think about as potential suspects in a murder case want to put themselves closer to the crime that you're investigating, right?
Correct.
Like, unless they're coming in and say, I confess I did it, right?
Yes.
Some people do just confess.
Yes, sir.
But unless they're going to confess, people are typically trying to minimize their involvement in the offense, correct?
Yes, sir.
And as a detective, you're trained to pick up on the fact that suspects frequently minimize their involvement, right?
Yes, sir.
And there are lots of ways to minimize involvement, correct?
Yes, sir.
One of which is to point the blame at someone else, right?
Yes.
One of which is to give you what they think you want to hear, right?
People do that. Yes, sir.
They're trying to figure that out. It's a cat and mouse game, right?
Yes, sir.
And you're supposed to be watching out for those things.
Yes, sir.
And you're also trying to assess whether or not what this person's telling you can be independently corroborated, right?
Correct.
Because that's the key in case someone has lied to you so badly that they're not credible, right?
Sure.
You have to think not just in terms of what you're going to ultimately decide, you have to think about how this will be presented and explained to 12 people one day.
Yes, sir.
And so keeping those things in mind, if somebody lies to you for a significant portion of your interrogation of them, that's going to send off some red flags for you, right?
Yes, but people generally don't start by telling me the truth.
Okay, fair. But people generally either come clean shortly thereafter, or you're going to write off what the rest of they say is also potentially false, right?
Unless I can support it somehow with other evidence.
Okay, fair enough. So Jeremiah Rodriguez lied to you for a significant portion of your interrogation of him on both occasions. Wouldn't you agree?
More on the first one. Yes.
Definitely more on the first
Yes.
one. Like for what, almost half the interview.
Yes,
He told you he wasn't in the car that day.
correct.
He said he was watching Redbox videos with his siblings at home, right?
Yes, sir.
He indicated he didn't even see these people that day.
Yes,
And he persisted in that for a very long time.
correct.
And then even after he gave up that he actually was in the car, for the rest of the interview, he told you there was another person in the car.
Correct.
I think his name was John, right?
That's correct.
And he just, that John was sitting in somebody's lap, right?
Correct.
Okay. Jeremiah Rodriguez, you mentioned earlier that you requested the generation of SID or SID numbers for Jalen Bell and Tamar McIntyre, right?
Yes, sir.
Meaning you intended to charge them with capital murder.
Correct.
And when I say charge, I mean, you're going to present this information to the DA's office, you're going to apply for an arrest warrant, you know, that process.
Yes, sir.
You did not do that for Jeremiah Rodriguez,
Yes, sir.
despite the fact that he lied to you for at least an hour in total.
I didn't feel there was enough for capital murder
Based upon what he told you.
on Jeremiah. Yes, sir.
Okay. Joanna told you that Jeremiah had a gun, right?
Yes, sir.
That Jeremiah was a drug dealer,
Yes, sir.
that Jeremiah had photography equipment, right?
That he had photography equipment?
You don't recall that?
No, sir.
Okay. Would it surprise you if that was something that was discussed in there? or
No, I mean, I believe you.
Okay. Joanna Reyes was avoiding talking to you for months before finally you got to speak with her, right?
That's correct.
And you only got to speak with her because she was arrested out of county.
That's correct.
And she was arrested in Odessa, right?
Yes, sir.
A long way from home.
Yes, sir.
And she also was trying emphatically to suggest that she didn't know anything about this, that it just happened, right?
Yes, sir.
She told you for a lengthy period of time that she wasn't even in communication with Mark Saldivar, right?
Yes, sir. They had communicated. It had been like over a year or something like that.
And that Tamar McIntyre was using her phone to communicate with him.
Yes, sir.
She eventually admitted that wasn't true, right?
Yes, sir.
So she was similarly trying to minimize her involvement.
Yes, sir.
Okay. And so you didn't ask Joanna Reyes for her phone in that interview, did you?
No, I didn't, sir.
And Joanna Reyes in that interview never told you that someone else broke that phone.
No, sir.
Okay. Yeah, it's good practice to try and get the phones of people involved in homicide or this, at least witnesses this close to the action in a
Yes, sir.
homicide, right? For all sorts of reasons, correct?
Correct.
In particular, in this case, what people knew and what was said to them is important, correct?
Yes, sir.
So, I mean, if things are as Joanna portrays it, then, well, I'll withdraw that question. One moment. You were asked some questions and there was an objection, so I don't want to go into the substance of it either. But you were asked some questions at one point about information that you received from someone other than Jeremiah and Joanna. I'm just going to ask it. Did you receive a Crime Stoppers tip in this case?
Yes, sir.
And fair to say, you later learned that Crime Stoppers tip was from someone who is one of Jeremiah's friends, right?
Yes, sir.
So I gather the thought crossed your mind that Jeremiah was trying to feed law enforcement information through the Crime Stoppers tip.
I didn't think that. No, sir.
Okay. It didn't strike you as unusual that a Crime Stoppers tip came in that eventually would be traced back to someone very close to Jeremiah Rodriguez?
It was an anonymous tip. It's a Crime Stopper tip, so I have to work and develop them. It's not trying to determine if so you're trying to say if it's false, but
Let me ask you this.
because I could corroborate details of the Crime Stoppers tip. So things that mentioned in the Crime Stoppers tip, I already knew.
Okay, well, let me back up. If somebody wants to try and sell you on a particular version of the story, and they encourage other people to go in and corroborate their version of the story through an anonymous tip, then that isn't really corroboration, right?
So again, sir, I didn't just go with that. I had other evidence, the physical evidence, the witness statements, which still supported what the Crime Stoppers said. And I did still talk to people and mention in the Crime Stoppers said.
Okay,
Eventually.
but when we talk about the witness statements, we're talking about Joanna Reyes and we're talking about Jeremiah Rodriguez, right?
I meant the independent witnesses also.
Who we've discussed at length, accounts differ as to what they say, right?
It's what they saw, sir.
Each of them, what they saw, right?
Yes,
Okay. You don't, because it's an anonymous tip, there's no way for you to understand if the tipper has a motive when you're receiving the information, fair to say?
at that point, no, sir.
Right, but in this case, you did later learn that there might be a motive for that Crime Stoppers tip.
I didn't believe there was a motive as you're presenting, no, sir.
Okay. Similarly, like you didn't believe that you needed to walk a warrant for Jeremiah Rodriguez for capital murder.
Correct.
Okay, even though you know that some of the accounts indicate that Jeremiah Rodriguez attacked or hit Mark Saldivar.
Yes, sir.
Okay, and there's at least some account among all these different versions we've discussed where Jeremiah Rodriguez may have been armed, right?
That's correct.
And the physical evidence indicated that there might be at least 3 firearms in that vehicle during the time period that this occurred, right?
Yes, sir.
Okay, but we didn't walk a charge on Jeremiah Rodriguez.
Correct.
Okay. When Ms. Reyes was interviewed, she originally tried to lead you to believe that she was unaware that anyone had a firearm in the car when they got in that day, right?
Yes, sir.
But later on, you very casually say, what gun did Jen Bell have? And she just says 9mm, right?
Yes, sir.
Okay. Were you able to look at Joanna Reyes's Instagram account at all?
I didn't know, sir.
Okay, so you took her word for it about how this all went down and what was being arranged.
With the physical and other witness statements, yes, sir.
Okay, what else shows what was being arranged?
Just the contact between on the phone from Mark Saldivar with Joanna Reyes, sir.
Okay, you don't have the content of that communication, right?
No, sir.
You just know they spoke.
Yes, sir.
That would be consistent with her talking to Mark Saldivar, right?
Yes, sir.
We all know that she spoke to Mark Saldivar, right?
She said she did. Yes, sir.
Okay, there's nothing that leads us to believe she didn't speak to Mark Saldivar, right?
Correct.
But as to the content of it, nothing corroborates that, right?
That's right.
Okay. And she's given several different accounts of what exactly they discussed.
Yes, sir.
Okay. When you are investigating, you were asked several questions earlier about search warrants. You recall that questioning?
Yes, sir.
And that's pretty standard because of the Fourth Amendment. You need to get warrants to search certain places that you suspect might be involved in a crime like this.
Yes, sir.
And the information you received from these cooperators was that after the shooting, everyone went back to Jeremiah Rodriguez's house, right?
Correct, sir.
Did you execute a search warrant for Jeremiah Rodriguez's house?
No, I did not, sir.
Okay. Did you execute a search warrant for Joanna Reyes's house?
No, I did not.
Or a search warrant for any other place that they indicated to you they might have stayed in the last 2 weeks?
No, sir.
Okay. You did apply for a search warrant for the phone that you determined belonged to Tamar Mcintyre, right?
Yes, sir.
And when you applied for that warrant, you advised that you had reason to believe that Joanne Reyes was a person that Mark Saldivar had corresponded with, correct?
Yes, sir.
And have you reviewed that warrant recently?
No, sir.
Would it refresh your recollection to have the warrant in front of you while I ask you about it?
Yes, sir.
Okay, one moment. Let me try and find that for you. That's right. Yes. Thank you. Sergeant, I'm going to show you what's been marked for identification as JR1. Do you recognize that?
Yes, sir.
And is that the affidavit for search warrant for the iPhone that we've been discussing?
Yes, sir.
Okay. If you have any questions you don't recall, please feel free to refresh your recollection with that. So when you all found, and I guess let me back up. In order to get into that phone, you first applied for a search warrant to search that black Kia that was found in the parking lot of the Mexican food restaurant, right?
Yes, sir.
Okay. And then you discovered this phone through that search, correct? Okay. And in that, and so then you applied for another warrant to gain access to search the phone itself, right?
Yes, sir.
Well, I take that back. In between, you also applied for a warrant to obtain Joanna Reyes's cell phone records, correct?
Yes, sir.
Okay, so you had her cell phone records before you applied for the warrant to physically search the contents of the iPhone that was found in the car.
Yes, sir.
Okay. And the reason why you were able to get the warrant to obtain Miss Reyes's phone records was because you had taken Mark's phone that was handed to someone from SAPD at the scene at the Chick-fil-A. And you had mentioned that you were able to access his notifications that were coming up on the screen, right?
Yeah, they were just popping up on the screen.
And so you were able to call numbers
Yes, sir.
off of that. And looking at that phone and looking at those notifications, you were able to see that he had been corresponding with a phone number that you later determined to be Joanne Reyes's, correct?
Not on the phone. Not, you're talking about through the notifications?
Yes, sir.
No, sir.
Okay. So how did you find out that that number was Joanne Reyes's?
So I, through the phone, through the notifications, I found that it was somebody that appeared to be family members of Mr. Saldivar. Those are the numbers I reached out to. One of them was his brother. I told them who I was. I went out to the location and I spoke to them, gave them the initial information of what we thought was going on. They identified him. I couldn't give them identification for Mr. Saldivar. They gave me his number. I applied for a search warrant for his phone records. Once I got his phone records, I looked at the approximate time that Mr. Saldivar was seen leaving the house and when the shooting occurred. And that number came up, and so in researching the number, at that point, back in 2017, you could punch numbers into Facebook, like you just find people by their phone number, and Joanna Reyes' name came up. So
Okay,
through that process.
understood. So, but let me back up. You did call numbers directly off of Mark's phone, correct?
Oh, yes, sir.
Okay, and who did you call directly off of his phone?
There were different people that I spoke to, sir.
Random people that
Yeah,
you had
yeah.
spoken to that day. Okay.
Yes, sir.
And you were able to do that even though you couldn't unlock the phone.
That's correct.
Okay. And you were calling through, was Joanna Reyes's number one of the numbers you called?
No, sir. Not that I spoke to, no, sir.
Well, did you ever call anybody that you didn't get a hold of? Did you ever try to ring Joanne Reyes's number through Mark's phone?
Through Mark's phone, it was locked, sir.
Well, I understand, but you indicated in your reporting that you had Mark's physical phone from the Chick-fil-A parking lot, right?
Correct, sir.
And as you're trying to figure out who is this man, is this phone, whose phone is this? How is it connected? You indicated that you had called numbers off of the phone.
Oh, I'm sorry. I didn't mean I called them through the phone itself. I wrote the numbers down and then called them from the office phone.
Okay, so these would be numbers you wrote down from the search warrant of Mark's phone, or the numbers you wrote down by actually looking at Mark's phone?
Just looking at Mark's phone.
Okay, but you called them from your office number.
Office or my work cell. So, but no, I didn't, other than the ones that are logged in the prosecution guide, I don't,
So you don't believe you ever called Joanne Reyes's number?
don't believe I did. No, sir.
You indicated that Joanne Reyes and Mark Saldivar had been in telephonic communication frequent telephonic communication in the hours leading up to his death, right?
I mean, they had been in communication since like midnight the night before.
Okay,
Yes, sir.
so fair to say those would have been the most recent numbers
Yes, sir.
in Mr. Saldivar's phone,
Yes, sir.
but you didn't call them?
So no, I didn't call her number. I tried to contact her and then that's how I ended up finding her.
Okay, you tried to contact her,
Joanna Ray.
right? How did you find her number? Through the phone, right? But you didn't call that number.
No.
Let me kind of
Yeah.
narrow this down. I understand because we're talking about everything at once, and we're talking about a narrow span of time.
Okay.
I want to focus this questioning on the time period leading up to when you applied for a search warrant for that blue iPhone that was found in the car.
Okay,
Okay, so between the time that you physically acquired Mark Saldivar's phone and the time that you applied for the search warrant for that blue phone that was found in the car, let me just ask it this way. Did you ever believe that that blue phone that was in the car was Joanna Reyes's phone?
I didn't know whose phone it was.
Okay, did you suspect it was Joanna Reyes's phone?
No, I just didn't know whose phone it was.
Okay, but you had spoken to Joanna Reyes before you unlocked the phone or after?
You're talking about the blue one?
Yes, sir.
After.
Okay. Had you determined whether or not, had you acquired Joanna Reyes's call logs before you applied for the blue phone warrant?
Yes, sir.
Had you called any of the numbers on Joanna Reyes's call logs?
No, sir.
Okay. In your conversations with Ms. Reyes, she frequently offered up the explanation that she was afraid as a reason why she hadn't spoken out sooner or why she was in Ector County, all sorts of things, right?
Yes, sir.
And you tried to downplay how much danger she was in, correct?
I mean, that was just what she was saying. Yes, sir.
Right, but you were trying to explain that that wasn't as significant of a threat as she perceived it to be, right?
Well, by the time I spoke to her, Mr. McIntyre was already locked up, and that's who she seemed to be afraid of.
Okay. So that was the reason you were trying to give reassurance that there wasn't a significant risk.
I mean, I was trying to reassure her, but she sure felt like there was a significant risk.
In terms of what transpired after she gave you her whole account of things, you explained to her that she would likely be let out on bond, right?
For the warrant, for the reason she was there.
Right.
Yes.
Right. That she would be at liberty after your interview. She would be able to walk out of the room. Well, I mean, sorry, that she would be able to post bond and walk out of jail, that there would be an independent reason to hold her.
Yes, I told her I was in a file at large on her for capital murder.
And at large means that you're not going to be immediately arrested just because you filed the case doesn't mean they're going to be immediately arrested, right?
Correct.
Okay. So you said that she appeared to be afraid and concerned when she was talking to you, right?
When she was talking to me,
Yes, sir.
no, she expressed that I mean, she's locked up. Like I think she felt pretty safe there, but she was expressing to me why she felt that way.
Okay.
Yeah.
Did you go out and attempt to corroborate any of the things that she said making her afraid?
No, sir.
Okay. You didn't go and try to conduct an investigation in Dallas where she was, right?
No, sir.
All right. And you didn't talk to anybody in Dallas who she might have been living with or staying with?
No, sir.
Okay. And we already said you didn't acquire anything on her phone.
That's correct.
And you didn't even ask for her phone in the interview.
Correct.
Okay. You mentioned that you acquired DNA swabbing from the suspects, right?
Like physically from the suspect, physically from
Or
the,
you requested it
for Mr. McIntyre.
just for Mr. McIntyre?
Yes,
Did you have any DNA swabbing done on Mr. Bell?
no, sir.
Did you have any DNA swabbing done on Joanna Reyes or Jeremiah Rodriguez? Okay, just Mr. McIntyre.
Yes,
Okay. And you indicated that you never requested that that be processed against anything on any of the items of evidence, right?
yes,
And your explanation for that was basically you made the decision that you had enough to proceed forward without that information, right?
through the course of the investigation, yes,
So, I mean, you do recognize that that comes with an inherent amount of risk to not check for DNA, correct?
yes, sir, but like I mentioned, even if with the evidence that I had as physical witness and other evidence, as you mentioned, sir, I still believe that all that showed that.
And I understand what you believe. What I'm trying to get to is, I mean, for example,
Yes,
Jeremiah Rodriguez told you there was another man in the car named John, right?
that's correct.
And that he was sitting in someone's lap while they were driving around, right?
Yes, he did.
And you clearly make manifest to Jeremiah that you're not buying that,
Yes,
right? And then he starts to change his tune, correct?
yes, sir.
Right? And we've talked about how one of the problems with interrogating people is they're trying to tell you what they think you want to hear, right? And you have to kind of cut them off at the pass.
Yes,
And so let's say that you ran that serology and you ran that DNA and it came back to a man in CODIS named John. That'd be a problem, wouldn't it?
yeah, I mean, it would definitely change things from the evidence, physical evidence, video, witness statements that I had to that point, but I didn't have that indication.
You decided that was a low probability event and that you'll take the risk and you'll file the charge and you won't charge Jeremiah.
That's not the reason I didn't charge him, but no, that's, like I said, I was basing it on all the evidence that took out.
Bottom line is we just don't know what that DNA evidence would tell us.
It wasn't submitted, no, sir.
Okay. In terms of processing the automobile, there wasn't any work done to try and identify whether or not there was blood spatter in the car, for example.
That's, I mean, see, that's CSI's job, sir. I don't know that, I didn't get any evidence or indication from CSI that blood spatter or any other biological fluid was found in the car, no, sir.
Okay, so the thoroughness of their investigation is one of those things we talked about at the beginning where there are a lot of moving parts. You have to rely on their work. You have to trust it was competently done, right?
Yes, sir.
But if there had been blood spatter in the car, you'd want to know about it, right?
Yes, sir.
And you'd want to run serology on it, right?
But it wasn't found, sir.
Okay, and you don't know why it wasn't found. You can't say whether it wasn't found because it wasn't there or CSI didn't do
I mean,
their
that's what I
job.
choose to say. It wasn't there. Yes, sir.
As far as you're aware,
As far as I'm aware.
it
Yes,
wasn't there.
Yes, sir.
Okay. Going back real quick to the issue of her fear and Joanna's fear, right? One of the things that you point out to Joanna in that interview that I'd like to ask you about is Tamor and Jalen Bell obviously leave town. Tamor is found in New Jersey. Mr. Bell is found in Dallas, right?
Yes,
And your understanding from talking to Ms. Reyes is that she went to Dallas and then she went to Ector County. And,
Yes.
and maybe somewhere else, we don't know.
yes,
No one was keeping tabs on Jeremiah in San Antonio, as far as you know, right?
as far as I know, no, sir.
Okay. And you even ask her, well, if you're so worried about this, why would they just leave Jeremiah by himself?
Yes,
You
sir.
remember asking that?
Yes, sir.
Okay. I want to ask you a couple questions about that SD card that was found in the parking lot.
Yes, sir.
You said that you tried to access it just by plugging it into a computer like you would any SD card, right?
Yes, sir.
And it just wasn't working.
Correct.
So you sent it off you said for analysis. Can you just explain for us a little bit what exactly, who'd you send it to?
So I sent it to, San Angelo Police Department has a video investigation technical unit. They're the ones that generally collect surveillance video. They help us out recovering photos, sometimes from SD cards, not just on criminal cases, on other stuff. They help CSIs out with that. So that's kind of what they do. They're detectives.
Okay, and you sent it to them and they said, we can't get it to work, we can't do anything.
Correct.
And was there any follow-up after that? Like, are there any additional steps that could have been taken to try and restore that SD card?
They're the subject matter experts, sir. They didn't indicate that there was anything else that could be done. No, sir. So I would say no.
You deferred to their experience?
Yes, sir.
Okay. So, I mean, as far as the SD card is concerned, you don't know if it's a random SD card that someone else dropped in the parking lot, or if it belonged to the deceased, or if it belonged to someone else.
That's correct.
Okay. Did they generate any kind of a report to you?
Yes, they did. I'm pretty sure they did.
Okay. When do you think, as far as you were concerned, and your interview with Ms. Reyes is in September of 2017, is that right?
Yes, sir.
And then your interview with Mr. Rodriguez is in a similar time frame, correct?
Yes, sir.
And then you file the case with the DA's office, right?
Yes, sir. Yes, sir.
Let's talk a little bit about what your duties are as the detective on a case, the lead detective on a case, after you've taken that step of filing the charge with the DA's office.
Yes, sir.
Do you go back to sort of being eligible to catch other cases and to be reassigned to other work at that point? Or is it something where you file charges and you are frequently still heavily involved in the investigation? It's just that you've completed step one, which is I have enough to file a charge.
So the case is filed and we are still subject to receiving other cases.
Okay,
We have a caseload.
so you're sort of back to the normal routine, or, I mean, how many cases are you expected on a daily basis to be worrying about?
It varies, sir. Anywhere from half a dozen to more. Yeah.
Okay, so during this time period from April of 2017 until you filed the charges on it, this wasn't the only case that you were working for homicide, right?
Correct.
Okay, around that time, do you know how many you were handling?
I would have to say probably about half a dozen. I mean, I honestly couldn't tell you right off the top of my head.
Sure. But after you sort of file charges, is that sort of a mark in your book that while you're still the duty detective for that case,
Yes.
it's not something you're going to have to deal with every day from here on out? Like, it's kind of done as far as you're concerned.
Not as much as the other cases. Yes.
Because now it's the prosecutor's job to review your prosecution guide and decide whether they like what you did and whether they think there's probable cause to get an indictment on someone and those kinds of things, right?
Yes, sir.
Okay. So, to your credit, you mentioned several times things that you want to keep following up on about this case, right? In your prosecution guide.
Yes, sir.
And one of those things that you notated is that you'd like to see ballistics work done on the pistol that was seized off of Jalen Bell, right?
Correct.
And that was something that you notated back in 2017.
That's correct.
And Mr. Garahan talked to you 3 or 4 times. You were asking Dallas to get that to you, right?
Yes, sir.
And it took a long time to get it down here.
Yes, sir. To the point that I honestly don't know exactly when it got to Bear County.
So it was not a part of your decision-making process at all when you filed the charge. You filed the charge having never looked at or considered Jalen Bell's pistol.
Oh, yes, sir.
Okay. Am I
I mean, yes, I didn't know if it matched. Is that's what you're asking?
right?
Yes.
You decided to file anyway, despite not having that in your possession.
Again, yes, yes, sir.
Okay. You mentioned, like, we talking about delegation of duties again. You send the SD card off to those people and they come back and they say, in our expertise, there's nothing more we can do about this. You're like, okay, that's noted. Moving on to the next question. The collection of evidence itself is also not a detective's responsibility per se. That's left up to the crime scene investigators, right?
Generally, yes.
I mean, you have authority to tell a crime scene investigator, go process that, go collect that, photograph that, but it's their job to also be doing that without your direct input, right?
Yes, sir.
Okay. And there were several crime scene investigators involved in this case, right?
That's correct.
And each of them, when they get out to the scene, is notating their E1, E2, E3 for the thing that they're processing, right?
Yes, sir.
That gets confusing, can it?
Yes, it does.
And the goal is that eventually someone figures out what everything is and which scene it came from, and they give it that barcode, right?
Yes, sir.
And that's designed to kind of put the matter to an end and say, okay, this barcode belongs to this piece of evidence, and that is what it is, right?
Generally, that's the idea, yes, sir.
Okay. And in this case, the barcodes for the scene at the Chick-fil-A were generated by Kim Wong, right?
I believe so, yes, sir.
Okay. And Ms. Wong's no longer with the department, correct?
As far as I know, no, sir.
Okay. But you wouldn't have had anything to do with how they labeled their evidence or how the barcode is generated or anything else,
No,
right?
sir.
Now, in terms of, in this case, we have two pretty evidence-intensive crime scenes, right? We have the Chick-fil-A parking lot and we have the El Potosino parking lot, right?
Yes, sir.
And then, I mean, obviously the car is taken to a secure evidence bay where it's internally processed, right?
Correct.
But at the time that the car is discovered in the Mexican food restaurant parking lot, there's a be on the lookout for it, correct?
Yes, sir.
Who generated the be on the lookout?
I did.
Okay. When you do that, back in 2017, was there a way to link up information? I mean, like, if I'm a patrolman and I'm just going about my ordinary business as a patrolman, and I see something that matches your be on the lookout, and as a result of that, crime scene investigators are brought out to process a scene, how do they get the benefit of the notes and the field work and everything that was done at the first crime scene? How's that communicated to them?
So there's a record back then, there was a record management system. And that's kind of like the way we have now. We have a report, Mark 43, it's a report management system, which where we put our reports. And you're able to see other people's reports.
Okay. Would it trouble you to learn that we've heard testimony in this case that some people had not seen any reports when they made the El Potosino parking lot scene?
No,
That wouldn't surprise you at all?
I mean, I don't know if they did or didn't, you know, it's the resources available.
Sure.
Yeah.
And you have to rely on what they know, what they don't know.
Yes.
Okay. When you were not the first officer that arrived at the Chick-fil-A parking lot, right?
No, sir.
When you got there, had the crime scene tape already been set up?
The crime scene was secure already. Yes, sir.
Okay. Was there ever a decision to expand the perimeter of the crime scene?
No, sir, not from my recollection.
Okay. You're aware that the eyewitness accounts sort of start this story back on the access road of the freeway, correct?
Yes, sir.
And then eventually they pull into the Chick-fil-A parking lot, and that's where Mr. Saldivar dies.
Correct, sir.
So the crime scene that was drawn did not encompass those lanes of traffic or the curbs or the grass next to the access road itself. It was just essentially looks like the property line of the Chick-fil-A establishment, right?
Yes, sir.
Okay. Did anybody go to sweep the area of the access road, like to look at the roadbed of the access road or the curb or anything like that?
The roadway, not that I'm aware of, sir.
Okay. We are aware that different witnesses have said that they think they heard 2 or 3 shots, and some said 1, right?
Yes,
Okay. I'll pass the witness.
All right, does anyone need a short break? All right. So I'm going to have you all back here at 3:15. Is that enough time for everyone? All right, remember my previous instructions. Everyone, please rise for the jurors. And state, I believe it's your redirect.
Yes, Your Honor, thank you. Sergeant Warren, I believe it sort of came out on some questioning you had with Mr. Hunter, but you stated about a backpack that you saw Jalen Bell put on, and is that in the video of the El Patrocino Mexican restaurant?
Yes, sir.
And so, again, that may not be indicative just of him putting a backpack on that it was stolen. However, was that consistent with other information you had on the case?
Yes, his, Mark's brother said he left, with a.
Objection, hearsay, confrontation, Your Honor.
All right, with regards to hearsay, that'll be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, disregard the last statement.
Motion for mistrial.
Denied.
The testimony is already received. Was there indication that a backpack was involved in the taking, or that Mark's backpack was taken from him?
Yes.
Objection, that I think is the same. Calls for hearsay and speculation.
Overruled.
Now, again, the thing of itself, putting on a backpack by itself, I guess not a crime, right?
Correct.
But no case is done in a vacuum. Is that correct?
That's correct.
And what I mean by a vacuum is I'm going to take one factor and say, hey, is this person guilty or charged or should be charged with capital murder? So, for instance, if I say Jalen Bell should be charged with capital murder because he put that backpack on, in and of itself, it doesn't hold anything. Is that correct?
That's correct.
So that's what I mean by a vacuum. The fact is that it's the totality of everything that you did in this case that led you to believe up to that point where you filed for those warrants of capital murder against Jalen Bell and Tavon McIntyre that attributes why you believe they should be charged with capital murder. Is that correct?
Objection, leading compound question.
All right, with regards to compound question, that will be sustained.
But is any case that you work up, you just work it in a vacuum and you don't use everything that you have in a case?
No, sir. We try to combine everything, with conclusions after conducting the investigation.
Now, Mr. Hunter went over at length Jeremiah Rodriguez's statements to you.
Yes, sir.
In fact, he gave at least 2 statements to you that were reported. Is that correct?
Yes, sir.
And at length, Mr. Hunter went over statements that Mr. Rodriguez told you in those statements, in that video. Is that correct?
Yes, sir.
But in the first interview with you on April 30th, at that time, had you developed the suspect of Tamor McIntyre?
Objection, calls for an opinion on the ultimate question.
Overruled. You can answer the question.
On April 30th, the week after, through the investigation, I had developed the name of Samuel McIntyre.
And so when you interviewed Jeremiah Rodriguez, for all intents and purposes, as testimony was elicited from Mr. Hunter, that he minimized or was untruthful or lied to you at the beginning of that interview on April 30th, 2017. Is that correct?
Jeremiah?
Jeremiah, yes.
Yes, sir.
And at some point during that interview, as Mr. Hunter elicited from you, then Jeremiah was sort of, admitted some parts of what he was involved in of this case. Is that correct?
Your Honor, I'm going to object to hearsay and confrontation.
Your Honor, oh, sorry.
Oh, no, I'll hear your response.
Your Honor, response to that is that Mr. Hunter went over at length Jeremiah Rodriguez's statement. I'm trying to, one, to show that the consistency of those statements that Mr. Hunter elicited from the detective of Jeremiah Rodriguez.
I didn't offer any statement of Mr. Rodriguez's for its truth. In fact, I was trying to get the witness, and the witness did agree that those were lies. The state can't offer the self-serving hearsay just because I elicited false statements that the witness told the detective. The reason it's admissible while the defense crosses is not a reason.
Excuse me, if y'all can approach. All right, State, you may proceed.
All right, well, let me ask you this, Sergeant Wars. Jeremiah Rodriguez gave you a statement on April 30th, 2017. Is that correct?
Yes, sir.
And then he also gave you an additional statement on September 6th, 2017.
Yes, sir.
And combined with other evidence in this case, were the portions of this interview consistent with other corroborating evidence?
Objection bolstering.
Overruled.
Yes, sir.
And so you gained some knowledge from Jeremiah Rodriguez
Yes, sir.
from one interview at the sort of at the infancy of this investigation on April 30th, just roughly 7 days after the murder of Mark Saladar.
Yes, sir.
And then roughly September 6th, months later, you interview him again.
Yes, sir.
And between those two statements, there's consistency. Is that correct?
Yes, sir.
Objection bolstering.
Overruled.
And did you combine what you learned from Jeremiah Rodriguez and compare it to other evidence in your case?
Yes, sir.
For instance, the day before September 7th, I'm sorry, September 6th, you interviewed Jeremiah Rodriguez, but on September 5th, you had interviewed Joanna Reyes at the jail. Is that correct?
That's correct.
Objection leading.
Sustained.
Motion to instruct the jury disregard the question.
All right, ladies and gentlemen, you're to disregard the question.
Motion for mistrial.
Denied.
Did you interview anybody on September 5th, 2017?
Yes.
Who was that person?
Joanna Reyes.
Where did you interview that person?
at the Bear County Jail.
And with the interview that you formed with her, was that on, I guess, video and audio?
It was recorded on DVD, yes, sir.
And with her interview, the portions of that for your investigation, was that consistent with other evidence in this case?
Objection bolstering.
Overrule.
Yes, sir.
And was that also consistent with portions of Jeremiah's first and second interview?
Yes, sir.
And then combined with other evidence in this case, was it consistent with the conclusions that you made about this case of Tamar McIntyre's involvement?
Yes, sir.
And in the end, what was your conclusion?
Objection calls for opinion on the ultimate issue.
Sustained.
What did you charge Tamar McIntyre with, or what did you file? What charge did you file against Tamar McIntyre at the conclusion of your investigation?
He was charged with the capital murder of Mark Saldivar.
Just to clear up one portion, Mark Salvador's phone. Were you able, I think there was confusion earlier. I want to clear that up. Were you able to access the actual phone?
No, sir.
So actually have the passcode or access code to enter it and look at the call logs?
Yes, so I'm sure by now most people know that it's an iPhone, it's a notification. So the way he had this phone set up, whenever he got a call or text, certain, however you can select the notifications on the phone, those things pop up on their own. They're the settings that were set. So when I looked at the phone, not being able to access it, make a call, anything, I was able to see those notifications, and that's where I gleaned that information.
And then other information, as you testified to previously, that you received from the call records that is not part of the actual phone.
That's correct.
Thank you. Pass the witness, Your Honor.
Briefly, Your Honor. So you're aware that Cellbrite can crack into locked phones, correct?
Yes, sir.
It's a routine practice of law enforcement to break into locked phones, right?
Yes, sir.
And that was not done in this case.
That's correct.
Okay. You were asked about the consistency of these individuals' stories as it relates to your recommendation that these men be indicted with capital murder, right?
Yes, sir.
Obviously, as a detective, you have to understand and know the Texas Penal Code, correct?
Yes, sir.
And in this case, the contention is that the reason it's a capital murder is because it was done in the course of a robbery. That's what you recommended, right?
Yes, sir.
And you're aware of the elements of robbery?
Yes, sir. Yes, making demands, taking property without the owner's consent.
You're aware that a robbery first requires a theft, right?
Yes, sir.
And theft is a separate crime under Texas law.
Yes, sir.
Okay. And then in the course of committing theft, the person intentionally, knowingly, or recklessly causes bodily injury to another person,
Yes.
right? Or they threaten intentionally to use force or lethal force.
Yes,
Okay. So when we're talking about theft, theft requires that someone have the intent to permanently deprive the owner of their property, right?
yes, sir.
Okay. So when you talk to both Jeremiah and Joanna, in the course of their explanation of this, they were talking about how there was a demand for a bag, right?
Objection, hearsay.
Sustained.
Yeah, I think as far as Joanna is concerned, that'd be prior sworn testimony.
Objection, hearsay, Your Honor.
Sustained.
Okay. There was was it your understanding based upon your interviews with Joanna and Jeremiah that they were consistent with each other in that they were indicating that this was a demand for a bag?
Objection, hearsay, Your Honor.
Sustained.
There's nothing about the statements that you took from Jeremiah Rodriguez on either occasion or Ms. Reyes where they indicated to you that there was prior knowledge the bag would be stolen, right?
Objection, hearsay, Your Honor.
That's been asked and answered.
Sustained.
You do not have any video surveillance footage showing a struggle over a backpack while Mr. Saldivar is still alive, right?
No, sir.
In fact, the only footage or evidence at all of the backpack that you have is the footage from the El Potosino parking lot where you see a man putting on the backpack, right?
Correct,
And you never recovered a backpack, right?
correct.
Pass the witness.
No further
State,
question.
all right, is this witness excused or subject for recall?
Excused by the state, Your Honor.
Excused by the defense.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this case. If you'll leave whatever exhibits with the court reporter, please.
Yes, ma'am.
State, call your next witness.
State calls Luis Lopez.
Thank you.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, have a seat. Make sure you keep your voice up so members of the jury can hear. If
Okay.
you'll state your name and spell your last name, please.
Luis Lopez, Lopez.
All right, state, you may proceed.
Mr. Lopez, how are you currently employed?
I'm employed with inmate calling solutions,
Okay, and how long have you been employed with inmate calling?
about 11 years. Yes,
Short. For short,
yes.
and what is your title with ICS?
My official title is field tech.
Okay, and do you also act as a custodian of records for ICS?
Yes, I do.
Okay, and specifically as a custodian of records, do you maintain jail calls made from the Bear County jail?
Yes,
All right. Now, these calls, are they kept in the regular course of business?
yes, they are.
And is it a regular practice to maintain the records for the jail?
Yes, it is.
All right. And the calls that are made by inmates from the Bear County jail, are they recorded when they are released?
Yes.
Right? And can you explain to the jury how the calls are recorded?
As soon as the inmate picks up the phone, there's a little software that allows the system to detect. And then when they start dialing, then the system starts recording at that point. As soon as they press 1 to place a call,
Okay.
the way through.
And when the inmate picks up the phone and starts the call, is there a warning that the call is recorded?
Yes, there is.
Okay, and so how does one go about obtaining a copy of the recorded jail call?
Depends on who's asking, but most of the times it's through a subpoena or a request from, the person,
A law enforcement agency?
a law enforcement agency.
Okay, and I guess, can you tell the jury what the enforcer is?
The enforcer is a system where we keep all the records and make changes to the records for each inmate. So if somebody has an issue with the voice, we will go there and help them out with the voice through the enforcer. We also enroll them in the enforcer with their SID number and their PIN number. And then through the enforcer, that's where we listen and can get recordings from the phone calls that are made.
Now, you talked about the SID number. Is that a unique identifier assigned to each inmate in the Bear County jail?
As soon as they walk in, yes.
Okay, and does the SID number have to be entered to make a call from the Bear County jail to a recipient on the outside of the jail?
Yes, SID number and a PIN number that the person or the inmate has selected themselves.
Okay, And so can you explain to the jury, how an inmate would go about making a call from the Bear County Jail?
Excuse me?
Did you already explain how the inmates make their calls?
How they make their calls?
Yes.
They'll pick up the phone, they'll hit one to place a call. After that, the system will ask them to enter in their PIN number. At that point, they enter in their SIT number and their 4-digit PIN number that they have selected. Then after that, it will ask them to say United States of America for the voice recognition.
Okay. And when inmates are making calls from the Bear County Jail, do they have to state their name in the call?
Yes.
Now, I'm gonna show you what has been marked as state's exhibit number 118. I'm gonna take it out of its envelope, but do you recognize this disc?
Yes, I do.
And have you listened to the contents contained within state's exhibit number 118?
Yes, I have.
Okay, and are they a fair and accurate depiction of the recordings that are maintained by ICS?
Yes,
Okay, and do you know what unique identifier they were made from? The SID number they were made from?
yes, they have the calls all have their SIT number and a CSN number also that tracks the call.
Okay, and regarding state's exhibit number 118, who is the inmate and his SID number that made the calls contained on the state's exhibit number?
Last name Mcintyre.
First name?
Tamar.
Can you say it?
Oh, Tamar.
Okay, and what is the SID number associated with that inmate?
It's 108-5731.
Okay, and you've listened to the contents of state's exhibit number 118,
Yes,
and they're an accurate copy of the conversations?
yes,
Okay, and they were recorded on a device that's capable of making an accurate audio recording?
correct.
Okay, and have they been altered in any way?
Not that I saw, no.
Okay, and at this time, Your Honor, the state would offer 14 to grant defense for inspection.
Your Honor, may I have Boyd Dyer?
Yes.
Good afternoon, sir. How are you? You've reviewed the contents of States 118,
Yes, sir.
and how many calls are on this disc?
4.
There are just 4?
Yes, sir.
Do you know how long each of them is?
About 15 minutes each.
Okay. Your Honor, may we approach?
Yes. Yes.
All right.
Please be seated. You can proceed.
You have to let him know.
All right, defense.
No questions.
All right, is this witness excused or subject for recall?
Please say state your own.
Excused by the defense.
All right, the rule has been invoked. You're allowed to discuss your testimony with anyone during the pendency of this case.
Okay,
All right, thank you.
thank you very much.
And if you'll just leave any exhibits, state, call your next witness.
Yes, Your Honor, the state calls Lucy Salvador. I'm sorry. I think that the next witness, I believe, is a restroom break. She thought she had more time. Let me, if you don't mind, I'll just step out briefly and call my advocate to make sure.
All right, thank you.
No objection.
Using the restroom.
All right.
I think that's that's all the information I have right now, but I believe she's coming.
All right, thank you. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes, I do. All right, you can lower your hand. Cindy, are you able to hear that? The green light is not on, what I can tell you. On the microphone that she has. Oh, no, it is. Okay. All right, so you're able to hear? Can you speak? Just say. Hang on. Can you hear me?
Yes, ma'am.
All right, let me start. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes, I do. All right, you can lower your hand. Just make sure you keep your voice up so members of the jury can hear. And if you could state your name and spell your last name, please.
Lucy Saldivar, Saldivar.
All right, state you may proceed.
Thank you, Your Honor. Ms. Salvador, can you please introduce yourself to the jury?
Hello, my name is Lucia Saldivar. I'm Mark Saldivar's mom.
Okay. I'm gonna come up there. See this microphone in front of you,
Yes,
you can turn it like this, if you're gonna turn this way. Speak into that, because you're just a little soft spoken, okay?
okay,
Because everybody all the way back there needs to hear you.
okay.
Thank you. I could barely hear you. So, one, I believe you stated that, your son is Mark Anthony Salvador. Is that correct?
Yes,
And can you tell us something about, Mark Anthony Salvador, ma'am? Like,
He
what type
was-
of person was he?
he was my youngest son. He was a good son. He never got in trouble. He was always happy. Try to help his friends in any way he can.
Okay, and you know, I know that's a brief thing that you told us, thank you, but you know, did he have a certain passion that he really enjoyed?
Yes, he did. He wanted to do photography.
And was that something that he did often?
Yes,
And, you know, would he want to do that for his occupation?
yes.
And I want to show you what's been marked state exhibit number 142, 144. Please tell me if you can identify 142 and 144.
Yes,
And what are those photos of?
my son, Mark Soderbergh.
These are pictures, obviously, before he, was murdered. Is that correct?
Yes,
And
Yeah, Your Honor, I'm sorry. I'm going to object to the question, especially the phrasing of the question. I ask that you would
I
provide
can
a
All
rephrase.
right, the objection will be sustained.
motion to instruct the jury to disregard.
All right, ladies and gentlemen, you're to disregard that last question.
Motion for mistrial.
Denied.
Thank you. May I proceed?
Yes.
In state exhibit number 142, that picture of Mark, what does he have hanging around his neck?
his camera.
And this camera in this photo, was this one of his, well, did he have many cameras or just one camera?
He had a few, but that's the one that he used the most.
And that's, I'm sorry, that's the one he used the most?
That's the last one he got, so yeah.
From this picture well, let me go ahead and enter state, I'll, consider the defense to any objections of state 142 and 144.
Boyd Dyer.
Yes.
Ms. Saldivar, good afternoon.
Afternoon.
The photograph that shows the camera in 142, on the last day that you saw Mark, he left on foot from your house, correct?
Yes,
And you didn't see what he left with, right?
just his backpack.
Okay. Your Honor, I would just object to 142 on the basis that it's under 403 cumulative, and there's a lack of foundation.
All right, could I see States Exhibit 142 and 144, please? And defense, you said your objection is to which one?
Can we approach?
Yes.
One, do you know if Mark, the day he went missing, that you never spoke to him again. Do you know for a fact if he took that camera?
I think so. I couldn't find it in his room. It was,
You could not find it in his room?
No.
Did you ever see that camera again?
No.
Your Honor, at this time, the state would move to enter state exhibit number 142 of the evidence and prove the transferring objections.
Same objections and speculation.
All right, objection is overruled. States Exhibit 142 is admitted.
Thank you, Judge. May I publish to the jury?
Yes.
Now, this is state exhibit number 142. Ms. Salvador, is this the camera that was mentioned during your testimony just previously?
yes, sir. Yes,
And this is the camera that Mark owned,
yes,
and this is the camera that he used for photo shoots. Is that accurate?
yes,
Thank you. And then state exhibit number 144, is that another photo of Mark?
yes.
Thank you. Now. Was there anything else about Mark that, for instance, at a state exhibit number 144, that he had a passion or a collection of objects?
Yes,
What did he collect?
he collected gemstones.
Gemstones?
Yes,
And if I'm pointing at 144, looks like a necklace. Was that something what you're calling a gemstone type thing?
yes,
And was that, I guess, a very lay term, just a rock?
yes.
Okay, thank you. Now, on April 23rd, 2017, did you see your son that day?
Yes.
And can you just describe, if you can remember, obviously that day, when you saw him and what y'all were doing throughout the day?
Well, in the morning, we were working at the yard, on the yard. We came in, he took a shower, got ready. And he told me he was gonna go do the photo shoot. And I asked him if he needed a ride. He said no, that somebody was gonna pick him up.
And you stated a photo shoot. Did you have any indication of what type of photo shoot?
He didn't tell me. He did tell me he was a upcoming rapper or something.
Objection, hearsay, confrontation.
All right, with regards to hearsay, that objection will be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, you're to disregard that last statement.
Motion for mistrial.
Denied.
Now, you stated just now also that your son stated that somebody was gonna pick him up.
Yes,
And on that particular day, did you advise him of anything before he left?
Objection calls for hearsay.
Overruled.
Did you advise him of anything before he left?
I just told him to be safe, be careful.
I'm sorry.
To be safe and be careful.
Okay. Did you give him anything?
He asked me if I had any money, and I told him I only had $10, and so I gave it to him. He leaned over and got the $10, gave me a kiss. He said,
Objection,
love you.
hearsay calls for hearsay and confrontation.
That'll be sustained.
Now, when he left, do you remember him taking anything with him?
just a backpack.
Just a
That I
backpack?
recall. The
I'm sorry?
backpack. Just a backpack that I recall.
And do you remember what he was wearing by any chance?
It was black gym shorts. It was a vest, pleat. I think it was gray or blue. And he had some shoes and the socks had prints on it.
And, you know, this is a while back. This is 7 to 8 years ago. So why do you remember that?
I don't know, I just do. I remember exactly what he was wearing.
So this backpack, if you know, do you know the contents of the backpack?
No, sir. It was black, that's all I know.
But your previous testimony was he was leaving to be picked up to do the photo shoot. And did you have any contact with Mark after he left at that point?
No.
By text message or calling or
I
anything?
texted him and he replied. And then after that, I kept texting him and he didn't reply anymore.
And do you remember approximately what time he left
It was
or
around, it was after 4:30, I think.
after 4:30?
Yes,
And related to Mark, were you contacted by anybody other than Mark?
the detective,
And a detective with San Antonio Police Department?
yes,
And did they come to your house?
yes, he did,
And did they speak to you?
yes.
And on another day, did you also have contact with this detective?
Over the phone,
Did you ever view a photograph associated with this case of a wallet?
yes.
No. No. It's. I'm going to show you what state exhibit number 145. Now, is this a copy of a photo and also writing that you saw back on May 10th, 2017?
Yes,
And whose wallet is in that photo?
Mark,
How do you know that this black wallet is Mark's?
because I gave it to him, I bought it for him, I gave it to him, and I got it because of that little tassel it has.
Tassels and has. Now, is that the same photo that's state exhibit number 78?
Yes,
Your Honor, at this time, well, did you write something on this photo?
yes, it says, this is the
Objection,
one.
hearsay.
All right, the objection to hearsay will be sustained.
What I'm gonna ask you is, do you recall how many, when did you give this, wallet to Mark?
It had been probably about a couple of months prior.
Okay. Judge, oh no, okay. But that state exhibit number 78 is the exact same copy of 148, is that correct?
Yes,
Okay. That is the wallet of your son, is that correct?
yes,
Do you know where this wallet was found if you don't?
no, I don't.
Show you what's marked state exhibit number 107.
Yes,
Is this that same wallet? So, Ms. Seldor, I want to ask you, do you know a Joanna Reyes?
no,
Do you know a Tamor McIntyre?
no,
Or do you know a Jalen Bell?
no,
Or what about a Jeremiah Rodriguez?
no.
Just going to show you what's been marked. Just want you to look at this picture and tell me if you're able to identify the person that I showed you in this picture. State exhibit number 42.
Your Honor, I'm going to object to this question. We filed a stipulation on this exact issue.
Objection is overruled.
And I showed you that picture. Did you recognize the individual in that picture?
Yes,
Who is that?
my son, Mark, Anthony Felderwetter.
Thank you, Mayor. I'll pass the witness.
Defense?
Good afternoon, Ms. Saldivar. I just have one question for you. Did Mark have any other plans or appointments or responsibilities that day, that afternoon, that might have conflicted with the photo shoot that he told you about?
No,
Thank you, ma'am. Pass the witness.
No further questions for this witness, Your Honor.
All right, is she excused?
Please.
Excused?
Yes, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this trial. All right, you may step down.
thank you. Can you take-
State, call your next witness.
Your Honor, this time state rest.
All right, thank you. All right, ladies and gentlemen,
Your Honor, may we express our condolences.
no, I mean, you all can do that after. All right, thank you. Ladies and gentlemen, the state has rested at this time. What I'm going to do is release you all for today, and we're going to come back tomorrow at 9:30. All right. Remember my previous instructions. You're not allowed to do any investigation on this case. You're not allowed to deliberate with yourself internally or with each other or talk about this case to anyone. Everything that you need to know about this case has come from inside the courtroom. Does everyone understand? All right, everyone, please rise for the jurors.
Your Honor, the
Yes.
defense has a motion at the court's convenience.
Oh, now,
At this
oh, you can
time,
remain seated.
thank you, Your Honor. At this time, Your Honor, the defense would move for a directed verdict of acquittal. We believe that pursuant to Jackson versus Virginia, the state has not proven each and every element beyond a reasonable doubt to the satisfaction of a rational trier of fact. There are many things in material disputes still at the close of the state's case that have not been resolved.
What is in dispute?
I don't believe the state has established who fired the gun. I don't believe the state has established who was in the front seat of the car. I don't believe the state has established that there was a demand for property.
All right, just one second. So your first is, you don't think the state has established who's in the car?
No, I don't believe that the state has established that he fired the gun.
All right, so you don't believe the state has established that your client fired a gun?
Yes, Your Honor.
All right, and point number two?
They haven't established that Mr. Mcintyre was the individual in the front seat of the vehicle.
Okay,
They have not established that beyond a reasonable doubt. Obviously, they have.
and I'm taking, just so everyone is clear, based upon your statement to begin with, I'm taking that all of these points you're bringing up are that they have not proven it beyond a reasonable doubt. Is that correct?
Correct, Your Honor.
All right, so I have points 1, 2. What's point number 3?
So I said gun, I said seating. I don't believe that they've established the robbery element for capital murder. I do not believe that they have established beyond a reasonable doubt that issues related to self-defense, defense of third person, defense of property are not in play and not applicable. And for those reasons, Your Honor, we would ask that the court enter a directed verdict.
All right, so with regards to self-defense or defense of property, then that implies that there is an offense. There is an offense, but self-defense, for lack of a better term, justified. It's through self-defense or defense of property. Is that correct?
I believe that at this stage, Your Honor, particularly, and we will have further discussion at the charge conference, that if the
Well,
car.
if we get to charge conference, I'm keeping an open mind with your argument.
Thank you, Judge. I think at this stage, I think the court's question drives to the inquiry of confession and avoidance. But I do not believe that confession and avoidance would have to be a matter of consideration in a directed verdict because the defendants hasn't put on a case yet. And there has been sufficient evidence to raise those defensive issues. I think that the defense through cross-examination has met its burden of production of those issues. And therefore the burden has shifted to the state to disprove those defensive theories. But the problem that the state has, and a problem that they can't really, I think, avail themselves of by raising the concern of confession and avoidance, is that because they have provided insufficient evidence as to who was the shooter, what gun was used, where was Mr. Mcintyre seated, all of those fundamental questions, it's hard to even get to the questions of justification.
All right, so let's start with number 1, 2, and 3. All right, state, the defense says, number 1, that there has been no proof beyond a reasonable doubt, which I know the defense is saying no proof beyond a reasonable doubt that their client fired the gun in this case.
We have testimony from a witness, one that testified that he had fired the weapon. We also have statements that were elicited by defense about Jeremiah Rodriguez stating he fired the weapon. And then we also have numerous witnesses at the scene that state that the front seat passenger is the individual that fired that weapon. We had a phone belonging to the defendant in the glove box in the front seat of that car. We also have other portions of witnesses. And on top of that, we have a video from Chick-fil-A showing that the front seat passenger particularly shot was shooting or shot the individual on that particular day. So evidence does point towards that this individual was the person, one, firing the weapon. And I guess I sort of stepped into number 2 by accident, or not by accident, probably just went into it, that he was the front seat passenger. Hence, if he was the one firing the weapon, he is also the one that was in the front seat passenger. So they sort of do go both hand in hand. And so it's the state's position that we prove beyond a reasonable doubt, at least for the trier of fact, to determine whether we prove beyond a reasonable doubt at this point.
All right, and then with number 3, the defense states that the robbery element has not been proven.
Your Honor, there's been numerous testimony also on that portion of individuals that were at that intersection that stated, I quote, "Give me my dings, give me my dings." And then several individuals said that the individual was yelling, "Help, help, help." And then also the actions of the victim as he proceeded to be kicked out of the vehicle, but then tried to proceed to get back in the vehicle, and then also proceeded to jump onto the vehicle to obtain his items. So the state's position is that well within the robbery limb, that also the victim himself had damage to his face, and testimony that he was being hit, not only from people in the car, but also outside the car, stating that the victim was being hit and a gun pointed towards him or being threatened with a gun. And so the state's position is that we prove well beyond a reasonable doubt for robbery.
And Your Honor, just so the state has an opportunity to respond, because I didn't say it, but they have a right to respond in the course of the motion. In assessing sufficiency for these purposes, the court should also look to the accomplice witness rule in Texas and recognize that clearly both, as the state just stated, since all the individuals in the backseat of the car are said to have been involved in fighting with the victim, and Ms. Reyes was the getaway driver of the car, they are, as a matter of law, accomplices under Texas law. And as a result of that, the state is obligated, in order to overcome legal insufficiency, not only that a crime occurred, but they have to have corroborative evidence outside the testimony of the accomplices, which they have not done. The testimony of Detective Juarez plainly establishes that the physical evidence in this case does not point to a specific perpetrator, and that the physical evidence in this case does not mitigate against the possibilities of justification. And the only evidence that Detective Juarez seems to have in his possession that militates against an accounting of this that does not result in Mr. Mcintyre's conviction is the testimony of the two accomplice witnesses, or at least the testimony of the one and the interview of the other who did not testify. So they have not established any corroboration of anything other than a crime occurred.
All right, so defense's request under points 1, points 2, and points 3 will be denied. Let's move on to your stating, I guess, defense of property.
Yes, Your Honor.
All right, so with defense of property, if I'm incorrect, tell me I'm incorrect. I always keep an open mind. So I think both parties can agree that the force that was used, if it was defensive property, was deadly force.
I mean, the man was shot and killed.
All right, so y'all are, parties agree that it was deadly force with property.
The state agrees that it's deadly force.
All right, so have you all read the penal code on 9.42 about when deadly force for defensive property is considered justified? Because it states a person is justified in using deadly force against another to protect land or tangible movable property. And I think we can all agree if the property, in this case that's being protected, is a vehicle, that's movable property. Am I correct?
Correct.
It says if he would be justified in using force against the other under section 9.41, and when and to the degree he reasonably believes the deadly force is immediately necessary, A, to prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime, or B, to prevent the other who is fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime from escaping with the property. And 3, he reasonably believes that A, the land or property cannot be protected or recovered by any other means, or B, the use of the force other than deadly force to protect or recover the land or property would expose the actor or another to a substantial risk of death or serious bodily injury. So let's first address your point number 4, where you say defense of property.
Yes, Your Honor.
And
Obviously-
I say that because I want to understand your argument, counsel.
Yes. I mean, the car is tangible personal property. It's being destroyed in the course of this incident. It is it's property of another. And so the third party concept applies with respect to
Mhm.
the issue. First, there's gunshot residue found on the deceased's hand. The testimony received from the analyst was that it could be one of 3 things, which is that he fired a gun, that he was in close proximity to a gun, or that he handled a gun. The state has not offered any evidence that would establish which of those 3 is more likely, which I think creates the potentiality for a robbery or an armed robbery.
Wouldn't that be for a decision then for the jury decide as a trier of fact?
Well, the problem seems to be that since we've established by burden of production that he jumped onto the hood of Ms. Reyes's car and started kicking the windshield, I believe that we have shifted the burden to the state to disprove it, which they have not discharged fully because the best they can do is that there's a 33.3% chance, assuming they're evenly weighted, which they're not, that Mr. Saldivar wasn't firing a gun. The other aspect of it, Your Honor, is that there was also testimony with respect to the backpack containing sexual paraphernalia and a concern about sexual misconduct. That questions were posited to the defendant, and Ms. Reyes acknowledged this, that there was questions related to, are you trying to rape her? Are you trying to have sex with her? What are you doing? Those were things that Ms. Reyes acknowledged were said. There was obviously significant dispute about the remainder of her testimony.
So is your argument that if somebody says anything, they can say, well, maybe somebody was talking about, maybe somebody wanted to rape somebody, maybe somebody wanted to kill somebody, then that brings in self-defense of property or self-defense of person?
I'm suggesting that because the burden shifted to them, they had a responsibility to establish more evidence to rebut it. which they have not done.
All right, state.
Your Honor, may I add one?
Yes.
Point? There is ample law with respect to the damage done to the car,
Mhm.
not just to the damage to property, but that a kick, the heel of a shoe, and I'll provide the court with citations of my co-counsel.
All right, and we're not talking about a high heel. Are we talking about a high heel or a tennis shoe? What type of shoe?
Any shoe, I believe, would suffice as a deadly weapon, depending on the manner and means by which it was used. I
Okay.
think the law is clear on that. And I would suggest that even Sergeant Detective Juarez said that it was considerable force. And I believe the witness said in one of her interviews that he kicked at me through the window. And I believe the court will remember that testimony, recall that testimony. And I believe that that is deadly force of another. And I believe that defense can be of oneself or of another.
All right, state.
Yeah, I just don't think that this is the proper time to actually ask for this. I think that they're overreaching. I think that the whole premise that, I mean, one premise of deadly force to protect a property is to prevent the other who is fleeing immediately after committing a robbery. And that's exactly what the defendant is doing in this case. So he provoked any type of individual trying to obtain his objects from the defendant that took it from him during a robbery. So one, I think it's improper at this point for a directed verdict, because that'd be something that would be going to the trier of fact in this case and the jury charge. And there's so much overwhelming evidence of witnesses at the scene stating, and actually neutral witnesses, lay witnesses that have no association with either side, stating that the victim was the one being robbed. And that's the state's position, Your Honor.
I don't think that that's a fair characterization of the innocent bystander's testimony, for one. And for two, again, Mr. Graham is speaking confidently that Mr. Saldivar was the man robbed, and so that it really should be the other way around. But the only testimony in this case that has established that is the testimony of the accomplice, who is not the witness to be able to establish the corroborative detail necessary to establish that. So I think that as much as he can say that that's the state's position, the state has not discharged its burden, prove that beyond a reasonable doubt.
Well, what I can say is I think counsel has the definition for corroboration incorrect. But what I will say is the request in motion for directed to verdict is denied on all counts. And we'll be back here tomorrow at 9:30. Cindy, we can go off the record. So at 9:30, state if you have, yes.
May I make one other request?
All right, we're back on the record.
Yes, sir.
Cindy, we're back on the record. Yes.
Thanks. I would just like to say for consideration tomorrow that I believe the state has put Mark Saldivar's, the victim's character in issue. They had his lovely mama, who I apologize, but I worry when we don't give somebody a religious preference, but
Mhm.
I think by asking the question that were asked, specifically, and the response is he was a good boy, he never got in trouble, puts his the purpose of that was to put his character in issue. And I think that opens the door to the fact that the officers found, without using it in order to poison the jury's mind, but I think that opens the door to evidence of child pornography on his phone.
All right. I haven't seen any evidence of that.
Yeah. Excuse me for a moment. Your Honor.
Yes.
What was it? Do we have? There,
I don't want what somebody said. Is there evidence on the complainant's phone?
absolutely not, Your Honor, and I was incorrect. I misspoke.
All right, so,
However, I believe there will be a witness and I believe we are convinced that the court has ordered us not to go into it. But since the question was asked yesterday, I was confused as to
well,
the context. What I believe they have put his character in evidence, and if a witness has such evidence, I believe we're entitled to put that on.
well,
Your Honor.
the question becomes what evidence? If it's just somebody saying something,
I believe
then-
they're entitled to say they saw it or that he said it.
no. What I can tell you all, number one, so I think it's been established by the defense that you do not have any evidence that there was any child pornography on
The phone.
the victim's phone. And I say
Absolutely,
victim,
and I
but
apologize.
the deceased person's phone.
Yes,
So
Yeah,
all
we
of-
are not making that argument, Your Honor.
and
We nev- we
I
never
made
have,
it and I was
despite what
wrong.
Mr. Goldstein said.
All right. And then if you have a witness who's, I guess, going to come in and want to say something they saw, then the court will take that up outside the presence of the jury to see if it should, if it meets any
If it's
objections
a mess,
of the rules of evidence or not.
and we will approach outside the presence of the jury before we ask that question.
Yes, because that's in the motion in limine.
And the court has advised us accordingly.
All right, so we can go off the record. So if you all will be here, we're going to start at 9:30. If there is some witness who's planning to come in to testify about character, then I would suggest that that person I'm always nice saying, I would suggest they need to be here at 9. So if anybody wants to take them on voir dire outside the presence of the jury, that can be done.
Your Honor, I don't think we are there yet, but I can assure the court that we're not going to delay anything. But if we have such a witness, when we're able, I don't think we have a witness here right now, but assuming we are able to acquire such witness, the minute we have that, we will advise able counsel for the state. We'll call it to the court's attention and the court can deal with it as they wish. I don't think we got anybody to be here at 9.
Okay.
So we can sleep a little late.
All right, thank you. And so I want everyone to instate, I'm sorry, defense, I'm not holding you to this. How many witnesses do you potentially anticipate?
Your Honor, potentially there could be the most would be 6.
All right, so we're going to stay tomorrow, finish with the defense's witness. And you all need to prepare for a long night because we're going to go over the jury charge tomorrow night. And then we'll have closing arguments first thing in the morning on Friday.
And Your
We're
Honor,
prepared to-
I tell you 6 because that is the most.
Mhm.
It could be substantially less.
No, that's fine. We'll, once both sides have rested and closed, if you rest and close at noon, then you rest and close at noon. But just plan to stay so that we can go over the jury charge.